This is case number 24CR41416, the State of Ohio versus Aaron Jones. Mr. Jones is present before the court with counsel, Ms. Martin. Mr. Arnold's here on behalf of the State of Ohio. I've been told that there's an issue.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones.
I mean, like, I'm gonna fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor.
In military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you, you won't.
Man, it ain't no time, bro. I got 10 in, 4 left to do. I do not 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and you never know how good you might.
Buckle up, guys. Today we are stepping into a courtroom where confidence is about to collide with reality. Right out of the gate, the defendant insists on representing himself, claiming experience simply from being in trouble before. The judge calmly but firmly starts probing, exposing the gap between confidence and actual legal knowledge. This moment sets the tone. A man who thinks familiarity with court equals competence, and a judge who already sees where this is heading.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm sorry?
Cool.
It's not cool. It's you're making a huge mistake.
I'm do so. I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
do.
does not.
I mean, that's cool. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch.
All right, guys, this is where things start getting tense. The judge doesn't sugarcoat anything and repeatedly warns the defendant that self-representation is a terrible idea. Instead of listening, the defendant talks over the court, minimizes the risk, and treats prison time like it's nothing. You can feel the disconnect growing. This part shows how ego and stubbornness start overriding common sense, even as the judge spells out the consequences in plain language.
Long list.
Is anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only, I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. Do you want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so.
Now we're seeing the judge shift into damage control mode. He explains how shackles, jury perception, and appeal rights all factor into this decision. The defendant hears the words, but doesn't absorb the meaning. This is a key moment because the court is laying out protections the defendant is actively giving up. The warning signs are everywhere, yet the defendant keeps brushing them off as if none of it really applies to him.
I mean, that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. I ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case a few years ago.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the third degree is because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
That's correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any?
I don't understand the question you're asking.
You're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to...
This part is almost uncomfortable to watch. The judge asks basic questions about defenses, and the defendant clearly doesn't understand what's being asked. The frustration in the courtroom is real. The judge isn't mocking him. He's highlighting why legal training matters. This exchange exposes the core problem. The defendant wants control without comprehension, and the court is documenting that lack of understanding step by step.
I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? No, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have...
3 years, man. That's nothing.
Let me tell you something. When I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do. The one that's elected to go with the jury trial, so you keep on saying it's only 3 years, that's fine. All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
What is their opinion?
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
You will be required by law to follow the Ohio Rules of Evidence and the Ohio Rules of Criminal Procedure. Do you understand that?
Yes, sir.
Your lack of knowledge of procedural rules will not prevent this court from enforcing those rules. Do you understand that?
Yes, sir.
you would understand that your lack of knowledge regarding the rules of evidence and the rules of procedure will result in you waiving the review of those issues on appeal.
Here, the judge draws a hard line. He warns the defendant about courtroom behavior, respect for the process, and what will happen if things get out of hand in front of the jury. The defendant keeps repeating that it's only 3 years, completely missing the point. This moment is powerful because it shows authority versus denial. The judge is trying to preserve fairness, while the defendant continues sabotaging himself in real time.
You understand that?
Yes, sir.
If you have any difficulty in presenting a defense on your own behalf, any difficulty in complying with the procedural rules or the rules of evidence, the court cannot assist you in the presentation of your case in any way. Do you understand that?
Yes, sir.
You understand that the state of Ohio will be represented by an experienced trial attorney.
Yes, sir.
You understand that your right to represent yourself is not a license to abuse the dignity of this courtroom, and thus, if any disruptions during the trial occur, your right of self-representation may be vacated by me. Do you understand that?
Yes, sir.
If you choose to represent yourself when you're convicted, you cannot complain about the quality of your own defense, and it will be basically a waiver of your right to appeal the ineffective assistance of counsel. Do you understand that?
Yes, sir.
From any physical or mental disease or disability?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir.
Has anyone threatened you or forced you in any way to waive your right to counsel?
No, sir.
Have you been profiting in exchange for your right to counsel?
No, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes?
Now the court moves into formal territory. The judge goes through the waiver process, carefully confirming that the defendant understands what rights he's giving up. Every question is deliberate, and every answer becomes part of the record. This isn't casual conversation anymore. The court is building a paper trail that shows the defendant was warned, informed, and still chose this path, even though he clearly lacks the tools to walk it.
Yes, sir.
What's the issue with him?
I was never asked to remove the towels.
Yes, he was, man. He knew I had to use the bathroom. I don't know what else I'm supposed to say. I need to cuss.
All right, let's get through this, and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility, prison. After the presentation of the witnesses by the state and by your side, the defense, we will have closing arguments. Each side will have a few minutes to wrap up their case and present their argument to the jury. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. Shackles on your legs are going to remain there. Now, I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now, you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right.
This is a critical ruling moment. The judge addresses security concerns and decides the shackles will stay on, citing the defendant's history and the risk to the courtroom. At the same time, he explains how he'll minimize jury prejudice. This part shows the balance courts try to maintain between safety and fairness. Even while the defendant argues, The judge is quietly protecting the integrity of the trial.
So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes.
Cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of. Debatable, though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
Here we see the warnings repeat, but with more urgency. The judge again explains that self-representation will likely hurt the defendant's case. The defendant listens, responds, and still refuses to accept reality. This section feels like the last off-ramp before disaster. The court is practically offering a safety net, but pride keeps getting in the way. It's a slow-motion decision you can already tell will end badly.
On the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some counsel. I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin than that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the form in front of you.
What's the date?
Today's the 18th.
This is the emotional pivot point. Suddenly, the defendant hesitates. He mentions family, hiring a lawyer, and uncertainty. For a brief moment, it sounds like clarity might finally break through. But just as quickly, he reverses course again. This back and forth shows indecision under pressure and highlights how courtroom choices made in frustration can lock someone into consequences they can't undo later.
All right, Ms. Martin, you'll stay behind Mr. Jones as stands. Mr. Jones, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
Oh, I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason,
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was
Okay,
the purpose.
she's
still here and attached to my case. That's the
She's
whole
removing
purpose of
herself.
removing her was for me to be able to represent myself.
You will be. Sign the form. Read it.
was already signed.
All right, read. I'm sorry, I misspoke.
You see my signature was on that shit. You already said it was there. What are you talking about?
Mr. Jones, read the form. You said you
I already
didn't read
signed it, man. It's cool. Go ahead.
Read. Are you able to read and write?
Sometimes. Depends on how many pictures are. I ain't read it. I
Go get the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
for...
Ms. Martin standing by counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not allowed
what...
to object. I'm on counsel now. I'm allowed to object, ain't I? I did. I said I object.
What are you objecting to?
I'm
I
objecting to
removed-
Ms. Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her, was to represent myself, because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution or...
All right, guys, this is where it all lands. The judge accepts the waiver, appoints standby counsel despite objections, overrules the defendant, and orders the jury brought in. The moment is final and procedural, but heavy. The defendant is now officially on his own. This is the point of no return, where warnings turn into outcomes. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.